And the most enduring opinion in this was written by a concurrence written by Justice Robert Jackson. And I want to mention Greg Peterson, who's the president of the Robert Jackson Center in Jamestown, is here today filming this. Justice Jackson, many of you know, was a giant in the legal profession. He was a great intellectual, really didn't care for the likes of Harry Truman too much. He had been mentioned as a candidate for president, headed the trials at Nuremberg, was a towering figure as Solicitor General and as Attorney General, and he wasn't particularly thrilled, incidentally, that Truman had passed him up as Chief Justice for one of his poker-playing cronies, Fred Vinson. But Jackson's opinion was a masterpiece not because of this personality conflict, but because he went right to the heart of presidential power. And Professor John Barrett, who's a friend, is finishing Justice Jackson's biography, and he's explained that Jackson had really thought these issues out because as Attorney General during the Roosevelt years and also as Solicitor General, he had worried about the seizing of North American aviation by the president during World War II, but had concluded that was okay, mainly because that company was exclusively produced for the government and in essence was kind of amounted to a branch of the Pentagon in one sense. But Jackson lays out in eloquent fashion this spectrum of powers that the president has and in our constitutional system, and that is the enduring legacy of this Steele seizure case. In the first category, the president is on the strongest footing when he's acting with the consent of Congress, because then he's acting with all the power that Congress is able to give him, along with the power that he has as president. Then there's the second category, where the Congress has neither said he can or he cannot act. And so here we're in this, Jackson says, a zone of twilight, where the president's acting based on his powers under the Constitution, but there's often room for both the president and Congress to negotiate together here. And then in the third, the last, the bottom category, is when the president is acting when Congress has withheld, said he can't act. Here he's at the low point because he can only act with whatever power he has minus Congress's power under the Constitution. And the courts are supposed to be very wary here. He's in a danger zone. In this case, not surprisingly, Jackson concludes Truman is in that third category, the lowest category. The Constitution didn't specifically or implicitly even give Truman the power to seize American property like this. And in fact, Congress hadn't done this. And in fact, the time the Taft-Hartley Act was debated in 1947, they specifically rejected an amendment that would have given the president power to seize factories during times of emergency. So the president is at his nadir here. He's at his low point. Only Chief Justice Vinson and two other justices, and Vinson did play poker regularly with Truman, voted in favor of the president. And make no mistake about it, this was a stunning blow for Truman during the last months of his presidency. He was especially angry at his appointees, Tom Clark and Harold Burton, who he felt betrayed him. Ken Heckler told me there was blue smoke around the White House for a few days. But as you know, if you've read about Harry Truman, he wasn't one to keep his feelings masked. So he instructed Milton Cale to write down on one piece of paper everything that was wrong with the Supreme Court decision. Then he took that paper, put it in his pocket, and went to a dinner at Justice Black's house that was being hosted specially for him as a sort of peace offering from all of the justices. And no one knows exactly what Truman ended up saying to the justices, but we do know that at the end of the dinner, he turned to Justice Black and said, "I don't like your law, but this is mighty good bourbon."